I found this presentation. I'm on my lunch break. I cut it down, and I thought it'd be a good 10-minute presentation to share regarding the fundamentals of cargo claims. Don't move too fast and trying to skip my video. You may learn something. I did include some entertaining aspects as well. But when you have a lot of people coming at you, whether it's your supervisor or it's a customer or it's a motor carrier, and everyone's pulling you in different directions, as a broker especially, and an adjuster, with regards to payment, it helps to go back to the fundamentals of cargo claims. I'm Cassandra Gaines. I'm a transportation attorney. I've been in transportation my whole entire career. I've been in-house, I've been at a law firm, I've led teams of adjusters, I've led cargo teams for both logistics and trucking companies. So I love this topic, and I think that it's important that everyone learns the fundamentals of cargo claims, because you can be taken advantage of if you don't know at least these basics. I'll put out more videos getting more into the details, but remember this. Cargo claims are very hard. They're not for dabblers. So don't hire an attorney who's a dabbler. Don't go to an adjuster and hire an adjuster who's never done cargo claims before. You want somebody who's done this before, because you'll be taken advantage of if you don't know cargo claims. So when we start on cargo claims, I want you guys to remember something. Here we go. Remember this big, fat cat. I love cats. I love fat cats especially. And I want you to remember, when I say the Carmack Amendment, you're going to remember a big, fat cat. Yes, you're laughing at me. I know you are, and I'm going to regret this tomorrow. However, you will remember this concept more because of the big, fat cat. I promise. Either that or you can just make fun of me the entire 10 minutes. So we have disclaimers, okay? Let me try to tilt this at least a little bit so people can see the disclaimers. Yes, that's Dr. Evil. I love Dr. Evil. Some of you might not even know who Dr. Evil is. But the disclaimers for my video and for fundamentals of cargo claims in general, you must remember that we're talking about truckload only right now. Bill lading contract tariffs, they can change everything I'm saying. You can contract around a lot of this stuff. That's why you have to be careful with your contracts, folks. Whether you're a broker or you're a carrier or insurance adjusters, whoever your insurer is, that's going to change the way you analyze cargo claims. That's also going to change some of the things in my video too. I'll try my hardest in the next 10 minutes to switch between the two, but it's hard. Industry misunderstandings, you'll have people who will tell you, and they'll make it believable too, things about cargo claims, especially the Carmack Amendment, and they're wrong. And I'm hoping that my videos will help you get through that. And then contracts can change everything. So let's go to our next piece, the governing law. This is the most important part of my webinar. People get this confused all the time. You have two pieces of governing law you must remember. You have the federal regulations, right? The FMCSA can issue regulations. These are federal regulations, and you'll Google them, 49 CFR Part 370. And when anyone tries to tell you that the regulations say blah, go Google them first, because they're very easy to read. Then you have the Carmack Amendment, the big fat cat. Before I get into that, I want to introduce you to Mr. Carmack. This is Senator Carmack. As you can tell, he's insanely old. So is the Carmack Amendment. In fact, I'm pretty sure he wasn't a very nice guy, by the way. He was shot down dead in the streets of Tennessee. But at least he gave us the Carmack Amendment, so maybe that's one good thing he did. Carmack Amendment is very old. It's a federal statute, and it's been around forever. And the courts have interpreted it in all different directions, so it becomes very hard, and that's why cargo claims can become very hard. The reason why people confuse the Carmack Amendment with federal regulations is because the federal regulations address how to process a cargo claim. Sometimes the Carmack Amendment touches on it as well, but the Carmack Amendment is to govern who's liable for the goods that were damaged, lost, or delayed. And that's what the Carmack Amendment is for. The federal regulations just help you process claims. That's what you're going to use. I'm going to quickly go over a couple things. The federal regulations. And I want to show you this picture. These pictures are going to help. I know I'm not technology and there's better ways to do this, whatever. I don't know where I found this picture, but this is what I think about when I think about the claims processing. And that's because if you don't know the rules around processing cargo claims, you'll get taken advantage of. Here, there are minimum filing requirements. I'll go into those in just a minute. There are 120 days to pay, deny, or compromise. You can use that, brokers, when carriers are not responding to your cargo claims. You can also use the point down here, which talks about 30 days to acknowledge receipt of the claim. And then if anyone's challenging you, motor carriers, about how the goods were salvaged, you can use the federal regulations as well. Read them, Google them, know them. They're easy. Just print them out and highlight them. They're easy to read. Or you can call me. The filing requirements. So before I had the danger sign, now I found one that entangles. I don't even know where this comes from. This is a crazy guy. But when you go over to the filing requirements, you'll see what I put here. And this is how people can get tripped up. You have to have a written communication to the motor carrier, right? We're submitting cargo claims to the motor carrier. You can't notate the bill of lading and just call it a day. You can't call them up and say a couple pallets are missing and just call it a day. You have to actually write them out, a formal written communication. It says that right in the federal regulations. Not the statute, not CARMAC. It says it in the federal regulations. Written communication. Then you have specified damages or a specific amount of money. So you can't just kind of leave that part out and try to figure out your valuation later on. No, you need to put that in there, and most of the time you've got to include a commercial invoice. No retail values, and I'll get into that in another podcast, on another webcast. But you can't use retail value under the CARMAC amendment. And then you've got to say who's liable. It's going to be the carrier because you submitted it to the carrier. Easily said, but that's how you get yourself entangled, right? There are time limits. So I went over some of the time limits in the federal regulations, but there are time limits in CARMAC too, and people get the both confused, but they also get another piece. This is the common misconception. People think they have 9 months to file a cargo claim with the motor carrier, and they'll walk around saying that all the time. You don't have 9 months. Not unless it says it in a contract. Yeah, it says it right in the, Cassandra, it says it right when you look up the CARMAC amendment. It says 9 months. Yeah, but courts have said it can't just say it. It needs to be in a contract. So why I'm getting at this is if someone's trying to tell you that your claim is too old to be submitted, go back and try to find it in the bill of lading or in the contracts between the parties. And if it doesn't say 9 months specifically, then you can submit it. The CARMAC amendment. We are going to the big fat cat. Why? Because the big fat cat tells us who is liable. And there's really not a lot of wiggle room. It's pretty fat. It's the CARMAC amendment, right? So I want to make sure you guys see this. So the CARMAC amendment, federal preemption, what does that mean? That means that you don't get state law when you're talking about CARMAC amendment. It's only the CARMAC amendment. So here are the terms of CARMAC. Remember, it governs liability. It only applies to motor carriers and freight forwarders. Make sure you remember that, brokers. When someone tries to tell you that the CARMAC amendment applies to you, unless you have a contract stating otherwise, it does not. Motor carriers, freight forwarders, they are automatically liable under the CARMAC amendment. It's unfair in a way. It's unfair the cat's really fat, but it's also unfair that CARMAC can be really fat too, in that the motor carrier, if anything's damaged on the road, motor carrier is liable automatically. You don't have to sit there and prove that the motor carrier did something wrong. All you have to prove is that you tendered the goods in good condition to the motor carrier, and you have to prove valuation. And there are 5 defenses that a motor carrier has that I'll go through, but that's all you have to do. And that's why I call it the big fat cat, because there's not a lot of wiggle room. It sits on and trumps state law, and you're automatically liable, carriers. Then why am I saying that CARMAC did a good thing? Well, the reason why CARMAC has stuck around for so long is because it was too hard for commerce, for everyone to figure out who's liable how, to prove that the motor carrier is liable. And when you don't even know what happened out on the road, it jams up the court systems, it makes transportation more expensive, makes everything more difficult. So the motor carriers back in 1901, they gave up their liability arguments for Carmack Amendment, but in exchange, there are some benefits for the motor carrier. For example, valuation. Remember when I said you don't get retail value? That's the Carmack Amendment. And when I told you have to submit a commercial invoice, that's the Carmack Amendment. There are defenses for motor carriers, but most of the time if the goods are damaged, lost on the road, then the motor carrier is liable for the actual damages of the goods. Again, I love this, right? You've got the big fat cat, there's not a lot of room, and that's because you've back to the federal preemption. There are, state laws don't apply. Absence of contract, state laws do not apply here. And then you could actually file suit. If it's over $10,000, you can actually file suit in federal court because this is a federal statute. And transportation, interestingly enough, under the Carmack Amendment, goes back to the fat cat piece, is the fat cat's big and broad, so is Carmack. Anything that touches transportation can be preempted and trumped by the Carmack Amendment. So perhaps someone is accusing your claims folks at a motor carrier's claims analyst for doing something incorrect when they were processing the claims. Some would say Carmack trumps that. If it touches cargo and it touches transportation, Carmack trumps. It's the big fat cat. So when I talk to you about the strict liability, motor carriers are automatically liable. There are only a few things that a shipper or the broker, if the broker is representing the shipper, have to demonstrate. They have to demonstrate the cargo was tendered to the carrier in good condition. And that's just a bill of lading that's not notated. You can rely on that as long as the carrier didn't notate it. The carrier was delivered in damaged, the goods were delivered in damaged condition or they were lost. You have to demonstrate that to the motor carrier. And then you just have to demonstrate a commercial invoice. That's it for shippers and for brokers. The motor carriers are the ones who have to turn around and analyze the claim. In response, the motor carrier does have defenses, but there's a catch to their defenses. You'll hear about these defenses, but I'm going to teach you something. Pay attention. Okay, so we've got strict liability, motor carriers are automatically liable. But if the motor carrier can prove that they were not negligent and one of these 5 attach, for example, the motor carrier was not negligent at all and the shipper, improperly packaged the goods, and the motor carrier can prove it. And the motor carrier can prove that the motor carrier did not go fast, get in an accident, or slam on the brakes, probably using ECM data from its truck, then that's a good defense to the Carmack Amendment. But you can see it's a hard hurdle to get over. It's as hard as getting past a fat cat. So this is the end of my presentation. Watch it a couple times. Soak it in and go back to these fundamentals every time someone tries to tell you that things are wrong. And remember, contracts change everything. So if you have no contract in place, no terms of bill of ladings are governing, my video will apply. If you have a contract, you need to read through it and figure out what differs from what I'm saying here in this presentation. Till next time.